Yes, Mr. Weir.
My lords, may I start by handing up copies, please, of the relevant parts of the Countryside and Rights of Way Act 2000 and the one decision of Okparby, which references Vedanta, so I don't think you need Vedanta as well as Okparby. We've hole punched them and given them bulldog clips, so that if you want to, you can insert them at the end of your authorities bundle. My lords, turning to the Rights of Way Act first, I think the judicial intuitions of my Lord Justice Dingemans were far more accurate than my own. As one might expect, exercising the grey cells in a way I didn't. If you roam in accordance with the rules, you are not going to be a trespasser, but the Countryside and Rights of Way Act anticipates that you may not. And if you go to the Westlaw version we've got, it's page 7, top right-hand corner, and it's section 2, brackets 4. And so it says, if a person becomes a trespasser on any access land by failing to comply with, and truth be told, we've gone through, you can see 1A, because it's back on page 2, access land means land shown as open country. I haven't gone to look at Schedule 2 and so forth, but I think one understands that what it's saying is, we'll give you these rights, but if you veer off them, you'll be a trespasser. And then the OLA 84 deals with the consequences of your having been a trespasser. Okparby is a case in which the core issue, indeed the only issue on appeal, was whether or not there was an arguable case that the parent company, Royal Dutch Shell plc, owed a duty of care to Nigerians in Nigeria in relation to oil spills occurring in Nigeria, courtesy directly of the subsidiary company of Royal Dutch Shell. So that was the issue before the court, and there was a multiplicity of evidence which had been adduced by either party, much to the chagrin of each level of judge. And if you then kindly go to paragraph 127, under the heading the documentary evidence, is a single judgment of Lord Hamlin, with which all the other members of the Supreme Court agreed. You'll see he sets out how Lord Justice Simon in the Court of Appeal appears to dismiss the relevance of future evidence on the basis that a good arguable case has to be demonstrated on the basis of material currently available. I won't read out what he says, but the court can see that.
Yeah, and then he quotes Lord Briggs, which is much the same as Lord Justice Mummery said in the Doncaster case.
It really is, my lord. It's pretty much verbatim, which is why we didn't think it necessary. Then you get a gloss attempted on it. Well, that's a fair way of putting it, but the Chancellor, Para 128, applied a different test. And he said you need a clear prospect that new material will become available before the trial, which is likely to give the claimant a prospect of success. And Lord Hamlin says, no, thank you. See Lord Briggs in Vedanta. So we are where we were. My lords, the point at which I'd come to was now to seek to identify where the judge went wrong in relation to sections 1.3c and 1.4, which I take together because they have been embraced in one part of his analysis together. And I have 7 submissions to make in relation to this. First, there was a clear error of law in failing to appreciate the significance of the fact that Mrs Brown was an involuntary trespasser. As I've sought to show the court, he set this point entirely to one side, and as I've sought to show this court, it is a relevant criterion, indeed per Clark and Linsell, a very important one. Secondly, the judge sought to infer that finding there was an arguable case that 1.3c or 1.4 had been satisfied would lead to liability, that's how he describes it, being imposed on all homeowners in respect of all buildings and walls adjacent to the highway. But first, this is a clear error of law because the court at these stages is only concerned with all the circumstances of this case. And this case is where D1 and D2 are occupiers of a very large reservoir, not a building or wall. That isn't a trivial point, I'll come back to it. Secondly, the expanse of water was very close to a road. See the photograph that my Lord Justice Dingemans has evidently seen in the supplemental bundle. And my learned friend Mr. White's skeleton argument below, which was A, curved, B, had a 60-mile-an-hour speed limit, and C, no crash barrier installed by the Highways Authority. And further, there was a history of accidents at this site. So the question of whether...
Sorry, I was just asking that, so far as one can get from the pleadings, which is what we're dealing with this on, were 2 accidents in 2014.
Well, right? My Lord, yes and no, in that this is...
So we're referred to at the inquest, where they hit the wire and stopped.
Yes, it's pretty much exactly as your Lordship says. It's for the reference to it being page 79 of the appeal bundle, paragraph 18, in which it's pleaded. So page 79, in the middle of paragraph 18, the inquest touching upon the death of the deceased received evidence as regards a history of drivers losing control of their vehicles at or around the accident locus. And it's averred that the defendants are each aware or ought to be aware of the risk of vehicles leaving the carriageway at all material times. There had been accidents on the bend on inter alia 28 and 21 November 14. In other words, my Lord, we're not limited to that. We haven't had disclosure. What we have identified is through the inquest process, there's a history of accidents. We've pleaded the accidents that we're aware of at this stage. So that's accurately the position. Yes, which I believe through materially as your Lordship has observed. So we're not dealing with any road. If one then transfers ourselves to, say, a village, and as we know, in many villages across the country, you have the road, the ancient road snaking through around the pub and other households. Obviously, if it's a village, it's got a maximum speed limit of 30 miles per hour. The slower you're going, the less likely this is to be problematic in terms of causing the sort of damage which then may or may not, on a given set of facts, necessitate a duty of care and or a breach of that duty of care. Speed is important. The bend is important because it goes almost without saying. If you're driving along a straight road and there's a house on your left, you're that much less likely to veer into it than you are if you're on a tight bend. So it's very fact sensitive. We then come to the issue of the reservoir, and the issue of the reservoirs we're going to see when we look at its reference in the Hart case, but I'll take the court to it now. So, albeit in a different context, because this is guidance to a highways authority, your Lordships will see, if you go back to the Hart case, we're in Authorities Bundle tab 13, and if you kindly go to pages 194 and following, I'm not saying this is the guidance that's directly relevant, because this is guidance to Highways Authority, but I'm just going to take you to this guidance, if I may. And you'll see at paragraph 18, so I'm at page 194, my Lord, in the Hart case, paragraph 18, you'll see reference here to a Department of Transport standard which superseded earlier technical memoranda and the layout of roads in rural areas. And 3.1 said the objective of installing safety fences and barriers within the highways to reduce the consequences of vehicles leaving the carriageway and entering areas where it be unsafe to travel. And then over the page, you'll see, well, starting at 4.1 at the bottom of that page, criteria for provision of safety fences and barriers over the page. Safety fences should be installed on all new trunk roads where speeds of 50 miles an hour or above are allowed. Again, for an obvious reason. And then verges, do you see 4.2? Verges on other embankments where there is a road, railway, water hazard or other feature at or near the foot of the slope. And that guidance is the same as what you see at paragraph 23, next page, The 1968 Ministry of Transport Manual Layout of Roads in Rural Areas makes this clear. 3.17 safety fences. Safety fences are needed where it be particularly hazardous for vehicles to leave the road and necessary on both sides of roads on embankment where the height is 20 foot or more, or where there's a road, railway or river at the foot of the slope. So that's different guidance. It's not a guidance that we'll be seeking to rely on at court against the occupier, but it evidences what you might say is a matter of common sense, namely that there's a particular concern in relation to large pools of water. Because if you go into them inadvertently by going off roads, which is a recognised hazard, see the Yetkin and other cases I've taken you to, drivers do drive carelessly. This is well understood.
But if you're looking at all the circumstances of the case and the duty, then you'd expect the duty to arise on the highway authority designing the road, not the neighbouring landowners.
My lord, that is all part of the package of the issues and the balancing exercise. I don't say it's irrelevant. All matters are relevant. It is a matter which would need to be weighed into account. Am I entitled as an occupier to leave my bridge, in the rail track example, and just let the highway get on with it? Should I take steps myself? Those are the issues. They're triable issues. You need to see all of the evidence in order to make that assessment. You cannot prejudge that issue.
Are you talking about bridges that carry the railway across the road, where presumably rail tracks' main interest is that people don't bash into their bridges?
Of course, my lord, yes. But
which causes havoc to the rail system.
Of course it does, yes. But that's exactly the same way as it can cause havoc, it can cause injury. They don't want you to crash it. They may have, like so many people, we all have a sort of selfish interest, if you like, more concerned about the bricks and mortar than the car that's just crashed into the bridge. Okay. But you put chevrons up which have the function of preventing someone from driving their car into your bridge, albeit, no doubt, in the rail track example, for primarily selfish interest, if you like. I don't mean that unfairly on rail track.
Well, it's an entirely reasonable attitude for rail track to take. I mean, they're not being selfish. They're just serving their commercial interest. Well,
it's more than that, because it's a bit like the Selby case, which is a case against the Highways Authority, but it's the idea that actually, what if there was one that crashed into the railway bridge, and then a train was coming at the same time, and that led to a whole multiplicity of accidents. Would there be? That's a live issue. I can't say yes, it's entirely obvious to me there would be. That's the triable issue. Would there be liability for rail track that hadn't put the standard sign up that said vehicles only under 10 feet or 12 feet in height should go through this? Down comes the crane, crashes in, hits the railway, causes a chaotic major disaster. They're just triable issues, my lord. That's the point. They're actually all quite difficult issues. A lot of these issues, as we see, are difficult. But the point that I seek to make, my lords, is you have to look at all the circumstances of the case. Yeah. This is super specific, so it does not lead to this automatic liability across every village and all the rest of the understandable judicial concerns.
No, you've made that point very clearly, Mr. Ware.
My lord, thirdly, the court was not required to find that liability was made out, but that's, if you go back to what the learned judge said, that's what it reads as. At the end of 12, he appears to have equated the burden on the claimant, proving that there was a duty to place a barrier in any and all situations. This was a strikeout application. We had to show was the claim not bound to fail. If your lordship wants to see that again, it's tab 5 of the appeal bundle. Para 12, it's the logic sentence, page 58. He says the logic of the claimant's case would suggest that any occupier of land with a building or wall adjacent or very near to a highway, I miss out a bit in between commas, has a duty to place a barrier. That's what he says. He doesn't apply the claim's not bound to fail test. He equates it to...
Well, to be fair, in the second line of paragraph 12, he had referred to whether it was sufficiently arguable that the occupier arises.
Well, that all I can do is read the judgment on its face. You're right. Of course, the judgment needs to be read.
Well, that's an absurd argument. He's saying, well, if this is right, this would suggest.
Yes.
Whereas he's directed himself properly on 12.
Well, the judge has had regard to his own experience as an advocate and a judge. That's the whole of paragraph 13, which is not a reliable barometer for assessing the merits of a strikeout application, not least in an area where we can see there are precious few cases. Now, one can play games and seek to infer there are precious few cases because these cases get settled. That's as arid as looking at it in the opposite direction. There just are not many reported cases in this area. That's where we are, but you can't rely upon that and say, ergo, there can't be a duty. We'd never move on with the law. We'd always say, well, it's in stasis. It's stuck. Whenever I last remember there being a case, it's just not a reliable test to employ. Fifthly, and see here the order of Nicola Davies, Lady Justice Nicola Davies, at page 120. When, in short order, she makes the point referencing her own judgment in White Lion and James. This is page 120, paragraph 3, looking at grounds 2 to 6, when she says the fact that a risk is obvious does not inevitably mean that there can be no duty under the 1984 Act to provide protection against that risk. And I've taken you to the relevant passage in James that confirms that. And I also took you to the passage in, I think it's paragraph 14 in the judgment, in which, in my respectful submission, the learned judge appears to say, risk is obvious, ergo no duty to warn. And that's an error of law. It's part of the balancing exercise. If I need to go back to the James judgment, I happily will. The references in James, I mean, it's a passage in the judgment which is all about the proper analysis of Tomlinson in that context. And it's tab 25, page 493. It really starts at 492, para 78, under the heading Tomlinson.
Paragraph?
My lords, para 78 is headed Tomlinson.
Yes.
When you get to 79 over the page, in the middle of 79, you'll see that Lady Justice Nicola Davies says, as I read paras 45 to 49, Lord Hoffman appears to be placing the principle relating to a claimant's acceptance of the obviousness as a danger as one element in a balancing exercise going to the reasonableness assessment pursuant to section 2.2 of the 57 Act. And she makes the same point again at para 83, when it says, for these reasons, I don't read Tomlinson or Edwards as being authority for a principle which displaces a normal analysis required by section 2 of the 57 Act. What a claimant knew or should reasonably have appreciated about any risk he was running is relevant to that analysis, and in cases such as Edwards or Tomlinson may be decisive. In other cases, a conscientious decision by a claimant to run an obvious risk may nevertheless not outweigh other factors, lack of social utility, low cost of remedial measures, etc. And ditto at 88, when she confirms, 88, there is no absolute principle that a visitor of full age and capacity who chooses to run an obvious risk cannot found an action against an occupier on the basis that the latter has either permitted him to do so or not prevented him from doing so.
And that was where there was an agreed duty?
Yes,
because White Lion was an agreed duty case.
It was an OLA 57 case. Agreed.
Well, he was staying in a hotel and he sat on a windowsill.
Well, yes, but the whole argument of the defendant, which we see...
Well, they took a principle from Hoffman and took it to perhaps a logical basis, but it was certainly not the law.
Well, they took a print. My lord, yes, they took what they saw as a principle from Tomlinson, which I've called the sort of Tomlinson causation point, and thought that it applied to this case, and that was Mr. Walker's submission. It's set out as being it's paragraph 5 at page 474. So it's addressing the limitations or proper scope of what I'm calling the Tomlinson principle. So at paragraph 5, third sentence, or second sentence, the points raised in the appeals or issues of law. The essence of the appeal is contained in the first ground, namely the judge, having found the deceased had chosen to sit on the windowsill, part out of the window, and had recognised and accepted the risk of falling from the window due to leaning too far out or losing his balance, erred in law in failing to provide a principle that the person of full age and capacity who chooses to run an obvious risk cannot found an action against the defendant, etc. See Tomlinson. So what was said was it doesn't matter whether it's OLA 57 or 84 because, as we know, it's danger due to state of premises. It's got the causation test. And when you have a claimant, even in that context, and this is all subjective, we can see this is only being applied repeatedly using the words claimant chooses to. Every case references that description, bar none. Lord Hoffman, just in his key passage, references Lord Phillips' judgment in Donoghue saying chooses to. I didn't take you specifically to that part, but it's there in every single judgment, chooses to. Even then, in that case, that was not sufficient to block the claim. And what there was in that case was a defect in the window. And the defect in the window was sufficient with a guilty plea to trigger that it was reasonably foreseeable that steps needed to be taken. And so that put us in the world of Section 2.2 of the Occupiers Liability Act and 2.1 and 2.2, whether there is a breach of the duty of care. And then the Court of Appeal say that's a balancing exercise in which the fact that this finding has been made goes into the mix. And having come out of that, the Court of Appeal say there is a breach of duty. And then the Court of Appeal say, I need to now go through para 89, page 495. We now need to look at section 2.5 of the OLA 57, which is valenti, so putting it on a statutory footing. And then the Court of Appeal say the defence of valenti was always a defence available to the occupier of the property, and section 2(5) expressly preserves it. And I'd add we have exactly the same in the OLA 1984. And then the Court of Appeal analyse the facts against the appropriate test and see paragraph 97. So over the page again at 496. There is no finding that does your Lordship have that? So it's page 496. There is no finding that the deceased was aware of and expressly or impliedly accepted that the risk had been created by the appellant's breach of duty and by his actions. He was deliberately absolving or forgiving the appellant for creating the risk. No finding that in sitting as he did, the deceased was waiving his legal right to sue. They are findings which provide a basis for determination of contributory negligence. They don't go sufficiently far to meet the requirement of section 2.5. And then there was a finding of contributory negligence, I think it was 60 or 75%, which was upheld. In fact, it wasn't even challenged by the claimants on appeal.
Yeah.
So that's the ordinary proper route by which one goes through. It's highly exceptional that you fall within this very specific category of intention to take upon yourself the risk that is a Tomlinson case. Whereas the judge simply said, see Tomlinson, no duty to warn of the obvious risk. Sixthly, the judge has neither sought to nor performed the balancing exercise as required under both sections 1.3c and 1.4. So he hasn't considered, for instance, how setting up a barrier does not interfere with the use of the reservoir. This isn't one of those affecting activities cases. You know, you're going to close down this reservoir, no longer be used for public use, contrary to the Compensation Act or something of that nature. He hasn't considered the cost of putting up a barrier. He has not put into the mix that Mrs Brown was at risk of death on our submission, has occurred, or at least very serious injury if she involuntarily drove into the reservoir. And of course a range of other factors. And seventhly, linked to the sixthly, nor could he have performed the balancing exercise at this stage, because the evidence was not all before the court to enable it to consider, open inverted commas, all the circumstances of the case. And that's because it was a strikeout application before disclosure and the exchange of evidence, including expert evidence. And I think I was asked, well, what's disclosure going to show? Well, we don't know what it will show, the nature of disclosure, that they're sitting on documents. If they have documents which are adverse to their case, they're required to disclose them. We don't know what consideration, if any, D1 or D2 gave to this risk. There may be minutes, there are bound to be minutes of their meetings. This is what tends to happen. And it may have been raised after the accidents in 2014. It may not have been. There may be reference to other accidents. There may be reference to knowledge of other accidents. We don't know. Expert evidence will be required, and these cases commonly have expert evidence. If you look at, for instance, the Little case, which I haven't taken you because it's a decision at first instance, but it's the Bristol Quayside case, the defendants had two experts. One was an expert in risk assessment. We would expect there to be guidance, which we haven't needed to reduce at a strikeout application, guiding those responsible for the safe management of open water. So one would have regard to what guidance there is in the ordinary way to try to assist the court as to what standards the court may or may not impose. This isn't to replace the function of the court. Court will make the assessment at trial. Is Section 1.3 threshold passed? If so, has there been a breach of duty? This is all evidence that will go before the court in order to enable it to make that considered assessment. And applying the test as recently set out by Lord Hamblin or Parby, one can reasonably expect disclosure in expert evidence will add to or alter the evidence available to a trial judge. That's the wording that is used. That's as far as one needs to go. One can reasonably expect that they will add to or alter the evidence available to a trial judge when conducting that exercise. In short, it's a paradigm tribal issue. It's a breach of duty. And Section 1.3c is very close to a breach of duty, hence the observation of my Lord Justice Lewison, trying to divine what am I testing if I'm not testing breach of duty, which the learned authors of Clark and Linton were themselves trying to grapple with. Yeah. So, my Lords, unless I can assist further, that is our case in relation to...
I've only got 7 points. I thought you said there were 8.
I intended to say 7, my lord. It wouldn't be the first time I've intended to do something.
7. Fine.
What was the 7th? Because I've only actually got 6.
He couldn't have performed. The judge could not have.
He couldn't have performed it. Yes.
Right,
yes.
Sorry.
The one that didn't seem to meet with much judicial attraction was the 3rd, and it may be that if you thereby.
Anyway.
Right. Okay. Yes. Okay.
My Lord Justice Dingemans was not overly moved, I think, by the 3rd, which might have meant that the 4th became the 3rd, at least in a judicial mind, but it was the 4th submission. I think I got to 7.
Yeah. Right. All right. That's D1 and D2. So we move on to D3 now.
My Lord, yes, this is much quicker.
Yes.
I can just confirm, at trial there was a 57 Act pleaded in relation to the D1 and D2, was there?
I can certainly...
If you look at the pleadings.
I can certainly say it was fairly broadly pleaded at that point.
Yeah.
And as we know, covered sort of...
And I know you're not responsible for pleadings, but it never helps in strikeouts or reverse summary judgments if you put a scattergun, because judges might wrongly assume there's nothing in the case.
My Lord, respectfully, entirely.
Yeah. Well, no, and I appreciate that. And, anything that is said will be gentle. It doesn't help anyone.
No, my Lord, it is certainly right. My Lords, can I start with ground 9? Because as I say, ground 9, whilst it seems essentially to have been conceded, it goes to the issue of whether there's any evaluation left standing as far as one can evaluate pleadings at all. For me, that's not really a judicial evaluative judgment. It's just assessing the sufficiency of pleadings. But I do understand it to be common ground now that D3 owed Mrs Brown a duty. And it's very important to emphasise this because we're striking out a case in which it is common ground that D3 owed Mrs Brown a duty of care in relation to the design and construction of the highway in 1967. Obviously we're going to hear from Mr Panton, but that is my understanding. If you go to the end of the appeal bundle, tab 16, page 179, paragraphs 22 and following. So you'll see he summarised that our ground 9 was wrongly failed to find that the case against D3 constituted an action for misfeasance. And he says at 23, it's important to note precisely what the judge actually said when refusing permission, which was, ground 9 is misconceived because the sharpness of the bend and or the absence of a crash barrier do not alone constitute action or misfeasance. He notes how we say this is an erroneous assessment by the judge that allegations that D3 constructed a defective and unsafe highway raise an allegation of non-feasance. And he says respectfully, it's clear the judge made no such assessment. Rather, all he's saying is, this is my paraphrasing, the mere fact that the sharp bend doesn't of itself prove construction created a danger. The mere fact that there were no crash barriers does not itself mean the highway was dangerous. And my understanding of that is he is recognising that there is a duty of care. There was a duty of care owed by the Highway Authority to Mrs Brown in respect of the construction and design of the highway. And so I don't understand myself, but I also can do a reply to need to sort of rehearse line by line the list of authorities in support of that proposition. But when I took you to target and torfine, the important point is that construction and design includes what you don't put in. It's still positive. That's not an omission to act and hitting the Gorringe omission scenario. That is fundamentally, call it an action, call it misfeasance. You're not in an omission scenario, and target and torfine is a good working example of that.
So it was, I mean, it's a reverse summary judgment and strikeout, but the original pleading pleaded that the road had been constructed by the first and or second and or third defendant. Again, that's not particularly helpful, but one can understand the difficulties. But is it now an agreed position that it was constructed by the third defendant? Because I only get that from their defence, as it were, rather than anything you pleaded.
Yes, my lord, absolutely it's the agreed position. I now totally understand that the pleadings start with more of a grape-shot approach, but the appeal has drawn down to the core issues.
That it is now common ground on both sides,
yes,
that it was built in 67, yeah. That's very helpful.
My lord.
Thank you. Yeah.
Well, I don't know if common ground in 67 was definitely the date,
yeah.
But that it was constructed by D3, its predecessor in time.
I think, in fact, there was whether it was May or earlier. Yeah.
Yes, and the way it's pleaded is well, I'm going to come to the pleadings now, so I'll go through it.
And this is all really paragraph 20 of the particular claim.
Well, my lord, yes, I'll come to the pleadings now then, if I may. So I'll go into the pleadings, and then, if I may, I'm then going to go back to the judgment on this ground 9 point. But my lord, to turn to the pleadings now, it's going to be easiest to go through the pleadings in one go, if that's okay. So we're in the appeal bundle, obviously, tab 7, and it starts at page 76. And the sort of key parts of it, paragraph 6 over the page, the deceased lost control of her vehicle on a section of the highway where there was a sweeping left-hand bend, etc., going into the water. Paragraph 7, the road was subject to a 60-mile-an-hour speed limit. Paragraph 12, now to reach the response to the question of my Lord Justice Lewison. Paragraph 12, the third defendant and or any predecessor entitled was responsible for the construction and or design of the physical road and its surrounds, which forms the material section of the highway, which the claimants understand was in or around 1967, at the time the reservoir itself was constructed, when the existing road was realigned as part of the reservoir construction. So that's the case. Paragraph 18, I understand this is no way determinative, but nor is it irrelevant. Paragraph 18, the third defendant installed a vehicle restraint barrier on both sides of the carriageway at the accident lockers subsequent to the index accident at some point in 2018. then again, the history of accidents are not relevant because we're dealing with the duty in 1968 rather than the duty at a later stage. And then we move on to paragraph 20 at the bottom of page 80, my lords. Further on, the alternative, the deceased accident and fatal injury were caused by the negligence. I know it says and or breach of statutory duty, but we pass on that. We're in a negligence claim of the third defendant. And then in particular, may I simply focus on two parts of that. B, caused and or permitted the highway to be designed and or constructed without any adequate vehicle restraint, barrier or fencing, otherwise to protect vehicles from entering the reservoir from the highway. And it is perfectly plain, although a point is taken against us by D3, that caused and or permitted the highway to be designed and or constructed is an allegation relating to the time of design and construction of the highway. And then can I take you down to D, please? Caused and or permitted the highway to be designed and or constructed with a radius on the bend, I'll come back to this in more detail if I may, which was significantly less than the absolute minimum prescribed by prevailing standards, brackets, including memorandum number 780, design of roads in rural areas. And that's the essence of the case. And it is accepted, as I say, for these purposes, that that duty is owed. So may I kind of just leave the pleadings? Those are the pleadings.
Can I, sorry to interrupt,
Yes,
but may I just ask one question before you go?
Yes,
which is, if you read E, it might be possible to misread that as alleging a Gorringe, or the beginnings of alleging a Gorringe style failure to act in public law because it was so unreasonable to ignore that. That's not being advanced.
My lord, it wouldn't be unreasonable so to read that, because that in essence it is obviously an allegation post-dating of design and construction, and it doesn't stand in law.
No. Okay, I just want to make
no,
sure.
my lord, yeah, absolutely. For any avoidance, I hope that in the appeal skeleton it was crystal clear in the grounds of appeal, the basis upon which we are challenging the decision is absolutely totally limited to, and it's only grounds on which you have permission to appeal, totally limited to a complaint in common law negligence relating to the construction and design of the road.
You say the highway authority built a road next to a reservoir with the bend that was too sharp without any safety barriers.
Yes, my lord. Exactly that. That's it. And it's not uncommon. You can have breach now that leads to an injury later. And sometimes you do get these gaps. It's not uncommon. Obviously, all breach issues, we then could, the court can consider, well, were there any actions in between and all the rest of it. That can all go into the mix. These things don't qualify as automatically ergo breach of duty. It's ergo trial. May I kindly just go back to the judge's approach to the point of law, the misfeasance against non-feasance. So the judge's judgment at tab 5 at paragraph 26, starting at page 65, please. So I take you to this because para 26, learned judge starts, my findings upon these submissions are as follows. So this would appear to be the right paragraph to be going through. And then the first, the numbering system is that we're now in 26A1. I'm not going to read out the whole of that little paragraph. It may be that he's seeking to knock out one of the other parts of the case, but given he's referencing Hart, which was about construction and design, it looks respectfully as if the learned judge is actually saying that mere negligence in the construction and design is not sufficient. That is my reading of 26A1. We then go to 26A4, so we're now on page 68 at the top. That little Roman 4 is 26 brackets A brackets Roman 4. So that's page 68. And he says, finally, Morland J. founded his observations in favour of the theoretical existence of a duty, or Mr. Marrick would say the arguability of that, on the fact that the highway authority created a danger, para 67, and I turn to that issue and reject it in the next paragraph. That's, on its face, an indication that he is rejecting the existence of a duty for creating a danger. That's how I read it. The next paragraph, he references the case of Kane, so 26b, and forgive me, but I'm going to pause. Kane is one of these cases. There are, as I set out in our skeleton argument, there are a number of cases confirming that if you create a danger, you owe an ordinary common law duty of care on Donoghue and Stevenson terms. And that's Donoghue and Stevenson makes a big appearance in the Target and Torfine judgment. And if Kane is tab 11, page 157, I'm sorry, I'm doing the ducking and weaving between the authorities bundle and the judgment because I'm going to go back to the judgment, but this sets the scene for it. And Kane is a case where the defendants granted planning permission for developers to run a footpath right up to a corner of or apex of a road which was unsafe for people to cross. And so it was put, well, hold on, looking at Gorringe, etc., this can't be a duty of care case at all. This is all tied up with statutory duties and so forth. Not so, explains Lord Justice Simon Brown, because we are here simply concerned with the creation of a danger. See at page 163, paras 27.
So are we now in the authority?
My lord, I'm sorry, I was...
Yeah. Well, what they'd done in that case was they'd required the footpath to become operational before the road improvements were carried out.
Exactly right, my lord.
Right, 163.
163, my lord.
Yeah.
With a judgment to Lord Justice Simon Brown as he was then, paragraph 27. We've got a lot of... Oh, it's Stoven. It's not Gorringe. It's all Stoven and Wise concerns, which are very much of a piece with the Gorringe judgment that Lord Hoffman carries on apace on the same or similar issues. I would reject this argument. It's plain Stoven and Wise proceeded on the basis that the complaint against the council was not about anything which it had done to make the highway dangerous, but about its omission to make it safer. I'll pass on the rest, but it's all important. But para 28. Here, by contrast, the starting point must surely be the defendants did create the source of the danger. And he continues at 29. In short, the claimant seems to me to have not merely a realistic prospect of establishing a claim in negligence against defendants, but a positively powerful case. Is he much impressed on the facts of that case by the claim? But the point is, that was creation of danger, misfeasance, not non-feasance. So that's the Kane judgment. If we then kindly go back to the judgment below at page 68, you'll see that's what he's referring to. He says, in Kane, it was found that the defendant had created the source of danger because it required the footpath to be constructed, etc. I'm saying that, obviously the court's at liberty to read the whole of this paragraph, but to save time, you go down to the bottom. He says, I fail to see, therefore, how this decision supports the case alleged against the Third Defendant Highway Authority in this case. Now that, coupled with 26A4, looks remarkably to me like a rejection of the claim based upon a duty of care. He just doesn't see it bites in this case. That's my understanding of what's happened.
Yeah.
And for those reasons, I therefore say he was wrong to do so. I don't think I need to then sweat the point that he was, because I don't think my learned friend's pursuing that. But it does show that it vitiates his assessment in relation to D3 completely, and the court replaces any assessment he may have made. We then come to grounds 7 and 8, and again I'm going to go to the judgment first of all. I mean, the grounds themselves I've never actually taken the court to, apologies. But you have them for the reference at starting at pages 16, and we didn't set them out because it would take up too much space, and we're limited to page numbers in the skeleton argument. But you can see 7 and 8 at page 18 of the appeal bundle, and they're obviously linked. And what we say is that he wrongly held that it was not alleged the case was sufficiently pleaded, and 8 says. Wrongly held that the allegations were not evidenced. And we take that from the judgment because the judgment, if we can start at page 67, And we're now actually deep into 26A2. That's where we are. The upper paragraph, not the lower paragraph, is 26A2. And above the first hole punch, does the court see, in this case, neither is it alleged nor is it evidenced that what the highway authority created, brackets, the sharpness of the bend, either was dangerous in itself or that it caused this accident. And that's actually repeated pretty much verbatim at page 69, 26C. So just before 27, the judge says, and if it be the allegation that, unlike in Stovin, the third defendant had created a danger, that found us, because in this case, again, the same form of words.
Where are you, Mr. Weir?
Sorry, my lord, I'm at page 69.
69, yes.
I'm at 26C, that is 26C. Yes. The last part of it, 5 lines up, if it be the allegation that, unlike in Stovin, the third defendant had created a danger, that found us, because in this case, neither is it alleged nor is it evidenced that what the highway authority created, the sharpness of the bend, either was danger in itself or that it caused this accident. That seems to me to be identical to the wording used earlier. And this is then said by the judge in his reasons for refusing permission, see page 71, in response to ground 7. So page 71, response to ground 7, he says it relates to conclusions, which I won't read out, which it was open to draw on the case as pleaded. That's his approach. That's what he says he's done. It was open to me to draw these conclusions on the case as pleaded. So as I follow that, what the judge has done is as follows. First of all, what has he not done? Although my learned friend for the third defendant says he's essentially struck out the claim based upon the weakness of the claimant's case, and that's in his paragraph 7 of his skeleton argument. I'll just give you the reference, which is page 176. There's no indication here he struck it out based upon the weakness of the claimant's case. He struck it out based upon it neither being alleged nor evidenced that what the highway authority created was dangerous in itself or caused the accident. That's the basis. So he's taken a pleading.
I think
point.
he's right to say
Yes,
wasn't alleged that it was dangerous. I think he may well be wrong to say it wasn't alleged that it was causative, because paragraph 20 of the particular claim say that the accident and the injury were caused by negligence
yes.
of the third defendant, and then the sharpness of the bend is one of the particulars of that causative effect.
My lord, yes. Can I address that head on and understand this word dangerous? When one goes to the case laws, and Yetkin's a good example, there's reference to creating a danger, and indeed we saw it just now in Kane, and it's a convenient and ordinary way in which to describe it. But what actually is the court concerned with? It's called the common law duty of care. And so all that happens is, my Lord Justice Dingemans in a recent judgment asked for confirmation that no one wished to change the thrust of their submissions in light of the Meadows judgment. And the short answer is, no, I do not. Not now, not until I'm absolutely required to, because I stick to the traditional and orthodox approach to dealing with common law duties of care. And that would be to say, is there a duty? There is a duty. So all I need to show is carelessness, because it's a common law duty of care. I understand the use of the language dangerous in exactly the same way as we actually see it statutorily being employed by Parliament in the Occupiers Liability Acts. But there isn't some magic to the word dangerous. I don't need to say, it's dangerous, trigger, boom, I'm in. Out, don't use the word, I'm out. It's a common law duty of care. It exists. All I need to establish is a breach of the duty of care. And that's what's been pleaded. This accident was caused by the breach of your common law duty of care. See the particulars of breach. So that's my immediate response to the use of the word danger. I do understand why, and maybe next time it would be convenient to put it in or something, and it would avoid any argument, but it's not necessary, not anyway. It's not a trigger for establishing.
So in other words, what you say is the judge may be right, but it's irrelevant.
Well, he may be right in the most. I don't know.
He's right in the sense that you haven't explicitly alleged it was dangerous, but you say that doesn't matter.
My lord, it doesn't, and it's again. It's trying to. It's a respectfully. It's a remarkably shuttered approach to an incredibly important principle called the right of access to a court. In other words, when you choose to knock people out, this is my point about amending, not that I want to amend, but when you choose to say to someone, you, Mr. Brown, sat in court behind us today, you have no right to bring this claim at all in court. It just doesn't touch upon the court. Yes, they do a duty of care in relation to construction. Yes, you make allegations that you had exactly as pithily put by my Lord Justice Lewison. There's a road that's built, it's too tight, next to a reservoir without a barrier, but you cannot pursue it. And then one starts to say why, because what you didn't use the word danger.
Yeah.
There should be a mature approach to these matters. You need to plead sufficient, and then after that, it becomes a stylistic choice, which doesn't in any way detract from the force of the cause of action you are entitled to pursue in a court of law. So the learned judge seems to have said, you haven't pleaded breach, you haven't pleaded causation, and you haven't evidenced breach, you haven't evidenced causation. That's how it works. I said I hope I didn't have to make much of the evidence point. There is no requirement to evidence your case at a strikeout application. That's the end of that one. My learned friend, understandably, benevolently interprets the judgment below, not even to suggest that was a requirement. See his paragraph 21, in which he's attractively sought to reframe it as just saying, well, really, it's a pleading point. So either it is just a pleading point or it's a bad point, but it certainly doesn't stand.
And insofar as this was an application for reverse summary judgment on which you can adduce evidence, you say, really, in substance, this was a strikeout, and the fact you didn't put in evidence shouldn't matter.
This was my original submission to the court, right at the outset, to get that out of the way, my lord. It's a commonplace, in the same way that you put in a witness statement that's just a pre-skeleton argument, is that you say it's strikeout and or summary judgment, but it's strikeout. I mean, that's really what it is, because it's a no evidence-based assessment. And indeed, we're hearing now what the judge is saying. He's saying, on the pleadings. That's what he's saying. Always using this word evidence, and my own friend recognises it's just a bad point. He can't sit behind it. So we're left only with the pleadings. And then when we go back, I've already taken you through the structure of the particulars claim once filleted, as of course, respecting the observation of Lord Justice Dingemans, it always should be, but we don't live in a perfect world. It's how litigation unfolds, leads it to courts in the first place. But what we have here, if we just go back to page 81, are two cases. One, the bend, two, the barrier. And of course, they are, in fact, although we break things down into particulars of breach of duty, they have a composite or cumulative effect. Exactly as per, again, the summary of my Lord Justice Lewison, when you say, well, if you choose, I'm not saying the Lordship's endorsing, this is a triable issue. If you choose to build a road next to a new reservoir on a very tight bend and without a barrier, so it may be the tightness of the bend isn't what wins, but the barrier is. It may be not the.
Well, it's a combination of all three. It's a
combination. It's a package. So although we traditionally break down particulars and say boom, 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 but one must always remember exactly that it's a package. In relation to the package, and if we just nip back to the judgment at page 67, you do not see mention of the barrier. It isn't there. It's not even there. It's all about the bend. The barrier's gone for some reason. So part of the composite assessment is to have regard to it all. It's gone. So that would be suggested, even if there was a pleading point to be taken against the bend, it's not to be taken against the barrier. But this is silly because both are obviously good.
Well, I mean, you say it may be perfectly all right to build a road next to a reservoir with a sharp bend, provided you put a safety barrier on.
Well, Lord, it may or it may not be exactly, but I mean, what we've got is what we've got. So what we then have are, and I don't mean this. unfairly, I'm a learned friend, but he has worked to seek to justify that which the cards have been dealt with him by the pleading, to seek to suggest that the judge is entitled to say that it is not adequate. And when you look at para 20D, and if we just go back to para 20, it's not adequately pleaded. And he says that's because you haven't said what the actual radius of the road was. Well, the way it works in common law negligence is you say, what you didn't do is produce me a radius on a bend which was at the absolute minimum. You produced something that was significantly less. That's what it says. That's a regular pleading. You don't have to say it was X degrees and minutes and it should have been Y. You've said it has not reached the absolute minimum having regard to prevailing standards. It was significantly below that. The idea then that causation is not understood by a judge who says he's 40 years of experience in personal injury and doesn't understand that a road that's too tight on a 60-mile-an-hour speed limit is capable of being driven off by losing control on a too tight road and thereby oversteering, as we, I think, generally at the inquest thought had happened, and veering off into...
Oversteer and then overcorrecting. Yeah.
Yes, oversteering, then overcorrecting, and then going into the reservoir is very, very unfair.
Can I... Oh, sorry.
Well, I was just going to say the speed limit is not, in fact, one of the pleading obligations. It's not said the highway authorities have been encouraging people to drive too fast by putting a speed limit of 60 miles an hour on this stretch of road.
My Lord, no, that goes to being part of the factual matrix against which the assessment needs to be made by the highway authority when it creates and designs the road. Here I've got a road in a rural area, there are no houses nearby, so it's going to be 60 miles an hour unless there's some particular features they've made, so that would be expected. It's made at a certain speed limit. When you permit, it's not authority to drive carelessly, but when you permit people to go at speed, which I will call at speed as opposed to in a village, for instance, then they are liable to lose control, not least on very sharp bends. I mean, it's all relatively straightforward. It's why, respectfully, although it may have seemed like a sensible defensive measure with the grounds of appeal to attach a draft, particularly as a claim amended, I really don't need to amend these pleadings.
Yeah,
they do the job.
I think my lord had a question, and then I think we've got your point on...
Yes, sorry, yes.
Sorry, just on in relation to this point, it's apparent from all the documents that one reads that this wasn't raised in pre-action protocol. Now, of course, there's no formal requirement to do that, and you may say, well, this is then all the trial, but we are now in modern civil procedure rules, and you do expect good points to be up there and led with. And is there anything behind that? Why wasn't it even averted to in pre-action?
Well, Lord, I must confess I never really inquired about that because if I say it seemed a detail, I don't mean that again inappropriately in a sense that all these things are important in their place, but I didn't think it was a detail for the purposes of the appeal because at the end of the day the pleadings are here. If a party has or has not engaged in pre-action disclosure, and I don't know actually, I could take instructions and reply if I have anything positive to say, I'll say it, my Lord. But why? It may be partly a
well, sometimes people find these things out later, and there's no bar. But I mean, I take your point about things are for trial, but also the civil procedure rules is encouraged to ensure that people don't end up at trials to find out their cases.
I don't say it's not important. I just say it's not respectfully important for the purposes of the appeal, because by that point in time, the judge was faced with pleadings, and how they got there is something which can traditionally be dealt with on a costs basis if necessary in relation to getting to that point. If the defendant was really able to say, I really didn't understand until you've brought me to this. I've made this application only because maybe they get the costs of making the application, which they then should have dropped after that had been explained to them or whatever. But that's how it would be dealt with. But as a matter of good civil procedure practice, the Lordship's obviously making points that I have no answer to vis-a-vis the scope of pleadings and pre-action activity. But we are where we are vis the pleadings on an appeal.
Thank you.
Right, is that it, Mr. Weir?
My Lord, it's 3 minutes to 3. That is it. 3 minutes early of my time
Well done.
estimate, my Lord.
Thank you very much. Yes, Mr. White.
Well, it's just to signpost where I will be going. I'm going to start with 3 very short preliminary points.
I'm then going to deal very quickly with 5 issues that have arisen from Mr. Weir's submission this morning that can form something of a preamble to getting into the meat of my submission. I will get to the meat of my submission within the next 10 minutes, but so that you can rest assured that these preliminary points will not take too long. The first and important preliminary issue is to acknowledge at the outset that behind the facts of this case lies a tragedy, and one can only come to the facts of this case with the utmost sympathy for the claimants who have lost their wife and mother. I mean no disrespect to them by turning immediately to our task, which is to identify the legal principles that underpin any duty of care. And I do not shy away from my position, which is that in the circumstances, the first defendant, and it follows the second defendant, do not in fact owe duty of care to the claimants. And that will be the thrust of my submission. My second preliminary point is to get some short points out of the way that I don't need to dwell on. The first is, there's no real dispute about what the test that the judge needed to apply and indeed did apply in relation to summary judgments and strikeout is, so I don't propose to spend any time on that. The second is that whilst it's possible to dispute how adequately the judge signposted whether he was dealing with section 11A and or section 13C, and I contend that he did in fact deal with both, it doesn't really matter because they are definitely an issue now, and so I simply propose to go through in the order as is set out in the statute, rather than reversing the order, which is in fact what I say the judge did. I say for completeness that he dealt with 11A in paragraph 14 and 13C in paragraphs 12 and 13. But nothing turns on that, so I don't propose to dwell on it. My third very short preliminary point is to just return to the question of layout. I'm obliged to my Lord Justice Dingemans for making the point that the photographs had potential to be helpful. No issue was taken below in relation to my inclusion within my skeleton argument. You'll find them in the supplementary bundle at page 195 and 196 and 197. And insofar as they're not good enough, I invite you to use Google Street View. You can go to Google Maps and search for Stivian's Reservoir and have a look around for yourselves. I've marked with an orange arrow on the map the location of the accident. The Water Sports Centre is up at the northwest side of the lake. That's the area where the first defendant leases, but I accept that the first defendant has a licence to use the whole of the lake, and to that extent it is therefore an occupier. That's it by way of the short preliminaries. The short responses to issues that have arisen this morning. Firstly, I wish to deal briefly with 2 questions from my Lord Justice Lewison in relation to the 1984 Act and the question of highway and the Countryside and Rights of Way Act. Can I take you please to the authorities bundle, page 11 and 12. If you haven't already taken the 1984 Act out of your bundle, which you might already have done. The answer to both of the questions that have arisen, that is section 1.7, no duty owed to persons using the highway, and what's the Countryside and Rights of Way Act doing here, is found by observing that the 1984 Act doesn't only apply to trespassers. The 1957 Act applies to visitors. The 84 Act applies to non-visitors. If there is a highway across land and you are present on the highway, you are there as of right, because it is a highway, it is a public right of way, so you're not a visitor to the occupier. So you couldn't be owed any duty of care under the 57 because you're not a visitor. So you would fall under the non-visitors provisions of the 1984 Act. And what Section 1.7 is doing is saying that no duty is owed under this Act in relation to highways. Effectively, when taken in tandem with Section 41 of the 1980 Highways Act, people who are on highways, maintainable at public expense, are owed that duty. So that's what Section 1.7 is doing there. What the Countryside and Rights of Way Act does is create some rights that go a bit beyond highways. Access land rights. And here I do part company slightly with Mr Weir, not in a way that matters at all for the purposes of this appeal, but just so that my lords follow the statutory framework. Section 2 of the Crow Act that deals with how people become trespassers if they break down a fence or a wall isn't what Section 1.6a, capital A, is here for. Section 1.6a is here for those people who are present on access land because they've got a Crow Act rights to be there. I'll return to what the significance of Section 6a is in relation to this appeal a little later. That's just to sketch out what the statutory framework is doing. Second short response to issues that have arisen this morning is to deal with Mr Weir's observations about Network Rail. He makes the point that railway bridges crossing over highways have chevrons on them or signs saying "watch out, don't crash your lorry here," and says on that basis that it is well established that occupiers put up signs to warn road users not to stray from the highway. In projecting over a highway, whether it's by a bridge or a signpost, someone responsible for that projection is potentially creating a nuisance. There would be a cause of action in nuisance against Network Rail if they projected over the highway and didn't take reasonable care. So to meet their obligation of taking reasonable care, in addition, of course, to protecting their interests, because I don't want people crashing into their bridges, they put chevrons up. It's nothing to do with the occupier's liability. It's a projection and therefore potentially a nuisance claim, and is of no illustrative value in the way that Mr Weir says that occupiers have a duty to signpost for motorists.
But in any event, the fact that occupiers do it doesn't mean they have to do it.
Also true. Third short response. It's said in reliance on the case that we were just given over lunchtime, Oak Parby and others against Royal Dutch, that we should proceed to disclosure and or experts. In reverse order, my contention is simply this as far as D1 and D2 are concerned, is never going to be an expert's case. We know what the facts are. There's no question of expertise required. And as for disclosure, my instructions are that pre-action disclosure has in fact been given, and this is no more than an attempt by the claimants to say, well, something might turn up. There's no reasonable basis to think that things will look any different. And
well, I think Mr Weir would say this could well be an expert case because you might have an expert in risk assessment who would give an opinion as to what a reasonable operator of water sports on a patch of water would or wouldn't do.
Well, he might contend that, but I would invite you to find that no court is going to say that an expert in risk assessment is required to help the court determine whether an occupier of land has an obligation to take steps to restrain people within the highway. And that's not only because, firstly, we've got the duty question, and I say there is no duty here, but secondly, even if there is a duty, the question of what is reasonable is exactly that issue that should be for a court to determine. The same issue as arose in Liddell and Middleton in relation to road traffic accidents. You don't need reconstruction experts to help the court through this. This is not a case that's going to turn on expert evidence, at least as against D1 and D2. As far as D3 is concerned, but I have nothing to say on that because That's between them. Fourth short point. It was suggested that the first defendant contends that carelessness by the deceased is a bar or a barrier to recovery. I do not contend that. I contend that the problem for the claimants here lies within interpretation of the statute. Fourth short point, it was suggested that I don't stand by what's been referred to as the watery existence point. That, I'm afraid, is wrong. It's right that I don't particularly adopt the expression watery existence. But the way that I put this below, you probably are close to it in the supplementary bundle, is on page 201 at paragraph 13. My point below was simply the fact that there is water does not mean there is a danger in the state of the premises. The judge didn't need to use the word watery existence. He could have just said existence. That's his paraphrase of my proposition. The existence or present water doesn't mean that premises are in a dangerous state. And I absolutely maintain that position. I will return to it. Finally, and this point can be taken as a bridge between my preliminary points and my submission proper. There is disagreement over the interpretation of section 1.1a, and if I can take you to that, please, on page 11 of the authorities bundle. I will start with how one should read the statutes before turning to Tomlinson. Mr. Weir helpfully identified the words within the 84 Act that we can put some square brackets around because they don't appear in the 1957 Act. That is, any risk of their suffering injury on the premises by reason of. And went on to say that danger, in what follows, should be read as meaning risk of injury. He submitted that he recognises that that creates a tautology, because you've then got a risk of injury by reason of a risk of injury, which he described as a problem in interpreting the statute. I say that there's no problem here, because danger does not mean risk of injury. Every risk is not a danger. That is, the staircases within this building might be fallen down by users of them. There is a risk of that. That doesn't mean that the staircases in this building are dangerous. Whether that's right or not, the claimants go on to contend that the state of the premises part of the statutory formulation doesn't really matter. That all you're looking at is there a risk of injury in association somehow with the premises? Well, I go on to contend that not every danger is a danger due to the state of the premises. The danger could be caused by choice, as in Tomlinson, or it could be caused by inadvertence. That's our case. But I say the key distinction is not choice or not. So I find myself in the position of simply inviting this court to read the words of the statute as meaning what they say. That is, we are looking to see if there is a risk of injury by reason of any danger due to the state of the premises.
Sorry to interrupt. In the Highways Act, when talking about footpaths, you require dangerous state. I mean, all footpaths you can trip on or anything else like that, but you do require a physical state which is more than just a possibility of injury.
Yes, albeit that Section 41 of the 1980 Act doesn't use the word danger.
No.
the obligation is to maintain the highway, and it's case law that's developed to tell us that some tripping hazards are dangerous and some are not. But my lord has my point that a pedestrian momentarily off balance might be caused to trip on any height difference, but that doesn't mean that it's a danger. I can come to my submission proper, which centres on Tomlinson. I am beginning, as I heralded, with section 1.1a, that is a risk of injury on the premises by reason of any danger due to the state of the premises. And in large measure, this appeal is a dispute over how one interprets the decision of Lord Hoffman in Tomlinson. And I submit that the key passage is in Authorities Bundle, page 245 and 246. I invite you to have that in front of you, and I'm going to dwell on it for a few minutes.
This is paragraphs 26 to 29, is it?
Indeed, and I'd go back a paragraph to 25 and include that in our consideration of what the key section is. Because at paragraph 25 he's identified the framework, and then at 26 to 29 he's got into the framework. And I'll go straight in at 26. Having identified that we're concerned with, is there a danger due to the state of the premises? In paragraph 26, what Lord Hoffman does is observe the trial judge said no. Is there a danger due to the state of the premises? The trial judge says no. He says effectively this is the same as any ordinary stretch of open water. He goes on over the turn of the page to look at what Lord Phillips, Master of the Rolls, said. He had been unable, top of page 246 of the bundle, Lord Phillips had been unable to identify the state of the premises, which carried with it the risk of injury suffered by Mr. Tomlinson. Seems to me that Mr. Tomlinson suffered his injury because he chose to indulge in an activity which had inherent dangers, not because the premises were in a dangerous state. So here we are looking for the danger in the state of the premises. The trial judge said there was none. Lord Phillips said there was none. We need to skip ahead, and I will come back to paragraphs 27 and 28 in a moment, but we need to skip ahead to 29 to see what Lord Hoffman says about this. And he says there was none. No risk to Mr. Tomlinson due to the state of the premises. Not, you will notice, there was risk to Mr. Tomlinson due to the state of the premises, but that is not the operative risk in this case. Those premises were dangerous, but it doesn't matter because of what Mr. Tomlinson chose to do. That is, this case is not decided on a Valentine basis. Rather, the trial judge, Lord Phillips and Lord Hoffman are all saying, in my submission, there is nothing dangerous about the state of the premises. We find that again in paragraph 28, as I work my way backwards, at letter F, where Lord Hoffman says, in this case, the water was perfectly safe for all normal activities. So what's paragraph 27 doing here? Mr. Weir says, well, it's drawing a vital distinction. It is only where someone freely chooses to engage with dangerous premises that the court should say that it's not the dangerous premises that caused the injury. But that's not what Lord Hoffman is saying. He's saying, well, there's no danger due to state of the premises. What caused this accident? Something else. In this case, it was the choice of Mr. Tomlinson. It is not only because Mr. Tomlinson chose to dive that the premises were not in a dangerous state. The premises were not in a dangerous state. What's the reason for the accident then? Well, it's Mr. Tomlinson choosing to dive. And of course, we know that what paragraph 27 is doing is heralding what Lord Hoffman is going to take the opportunity to say in a few pages' time to the effect of, we do not want our society to become too paternalistic. People should be free to exercise choice. So, that is my main contention in relation to Tomlinson. Our case is on all fours with it. Save that, Mrs Brown didn't choose to go into the lake. She chose to do something else. She chose to drive her car, an activity which is rightly observed by courts to be an activity that involves risk. That a particular risk has eventuated, that is not what she intended, is no different from the fact that Mr Tomlinson didn't intend to break his neck when he struck the bottom of the lake. Neither Mr Tomlinson nor Mrs Brown intended what happened, and there is no rational basis in my submission for distinguishing our case from Tomlinson. So I'm going to go on to list some reasons why the claimant is wrong to contend that the vital distinction is that Mr Tomlinson chose to do what he did, whereas in our case there is inadvertence in going into the water. I've dealt with the first one, the major one, which is what Lord Hoffman says. I invite your attention to what the other judges have to say about it. I'll take you first, if I may, to paragraph 69 and Lord Hobhouse's speech.
69, you say?
Paragraph 69 on page 258.
Yeah, this is Lord Hobhouse, yeah.
Yeah. I'm beginning just above the letter F, where he says, the state of the premises as the physical features of the premises as they exist at the relevant time. It can include footpaths covered in ice and open mine shafts. It will not normally include parts of the landscape, say steep slopes or difficult terrain in mountain areas or cliffs close to cliff paths. It will certainly be dangerous, requiring care and experience from the visitor, but it would normally be a misuse of language to describe such features as the state of the premises. The same could be said about trees and, at any rate, natural lakes and rivers. The Lords considered themselves dealing with a natural lake or river. It was just as natural as in our case. That is, this was a flooded quarry. We have a flooded reservoir. So what Lord Hobhouse is doing here is saying, effectively, your natural lake, like that quarry, like our reservoir, it cannot properly be considered to be the state of the premises. Rather, if we look at his
Well, he makes that point, although he's talking in 69 about natural lakes and rivers, the point that he makes at 73, just above H, says the argument fails on account of the fundamental point the state of the premises does not give rise to danger. So that must encompass the actual stretch of water in the Tomlinson case.
Yes. I don't know if it will assist, my lords, but in thinking about what state of the premises means, it struck me that in the examples that Lord Hobhouse gives, those examples all include something about the condition of the premises at a given time. So the footpath is in a particular condition because it's icy, or the mine shaft is in a particular condition because it's uncovered. This is not simply the existence of a footpath or the existence of a lake. It is the watery existence point, the mere presence of water. Even though people can drown in water, doesn't mean that premises are in a dangerous state. That's Lord Hobhouse's view. It is also instructive to see what is said where their lordships disagreed on this, and there was disagreement on this. At paragraph 53, page 253, we have Lord Hutton. He is observing that there's force in the argument that injury is not due to the state of the premises. But he goes on to incline to the view that dark and murky water, which prevents a person seeing the bottom of the lake where he is diving, can be viewed as the state of the premises. And if he sustains injury through striking his head on the bottom, which he cannot see, this can be viewed as a danger due to the state of the premises. If water were allowed to become dark and murky in an indoor swimming pool provided by a local authority and a diver struck his head on the bottom, I consider the danger could be regarded as due to the state of the premises. Notice that what he is doing is observing that where there is a concealed danger, there you have potential for danger due to the state of the premises, like our grid pile in Donahue and Folkestone. So he recognises uniquely among the lords in this case that there could be danger due to the state of the premises. But it is because someone cannot see the bottom, so when they dive, they don't know what they're getting into. A latent problem. And as we go through the cases, as I develop this submission, what we will see, I suggest, is that danger caused by the state of the premises means either some sort of defect or some sort of latent problem that is known about or ought to be known about by the occupier, but is not reasonably known about by the non-visitor, or indeed the visitor. In support of the proposition that I've just made, that Tomlinson was effectively decided on the basis that there's no danger due to the state of the premises, I pray and aid what was said by this court in James and White Lion at page 477 of the authorities bundle. And I invite your attention to effectively the second half of paragraph 18, where Lord Justice Nicola Davis summarises her understanding of what the Lords said in Tomlinson. She says, the House of Lords by a majority held that any risk of the plaintiff suffering injury had arisen not from any danger due to the state of the defendant's premises, or things done or omitted to be done on them within section 11A of the 1984 Act, but from the plaintiff's own misjudgment, attempting to dive into shallow water. There had not been a risk giving rise to any duty on the defendants. And even if there had been such a risk, it was not one in respect of which the defendants might reasonably have been expected to afford the plaintiff any protection under section. What she means there, she says 11C, she means 13C.
Is she right to say that that was a decision, a majority decision? Though Lord Hutton did have some reservations at 53, he went on, for instance, at 57, to approve what Lord McLaren had said in Stevenson and Glasgow. That is to say, where you've got a town on the banks of the river, there's always a danger to people who might fall in, but it's never been found necessary to fence it.
No, albeit that what Lord Justice Nicola Davis Lady Justice Nicola Davis has done is to read that as a section 13C issue.
Oh, I see.
Don't have to put a fence up every time someone might fall into water. And I don't need to contend either that Lord Hutton was wrong or that Lady Justice Nicola Davis was wrong. And I don't. It doesn't matter for our purposes whether it's where there's a hidden defect, it can be danger due to the state of the premises or not, because we are not concerned with a hidden defect in our case. I have included within the authorities bundle the case of Baldacchino. I'm conscious that it's a first instance decision. It is included for what it's worth as a case in which the judge has found that despite the fact that the claimant has gone into water and suffered injury because he's struck his head, there is no danger caused by the state of the premises. That's to meet the claimant's argument that if there is water, ergo, where there's an injury, it's due to danger due to the state of the premises. I see you flicking through for Baldacchino. You find it starting at page 309, and it's paragraphs 64 and 70 that are the important ones. I've put black sidebars next to them.
Yeah.
Everything I've said so far about Tomlinson and Baldacchino and White Lion can loosely be collected under the simple proposition: the existence of water on premises does not mean that there is danger due to the state of the premises. I am, you will remember, dealing with reasons why the claimant is wrong to contend that Mr. Tomlinson only lost because he chose. The claimant's effectively contending, well, these premises were dangerous, but Mr. Tomlinson only lost because he chose to. I turn to deal with the question of choice and invite you to conclude that there is no reason in logic to determine that it is only the free choice of an individual that means that risk does not arise from the state of the premises. Danger, I should say, does not arise from the state of the premises, but from what the individual does. It might be that the claimants have fallen into error by placing emphasis on what Lord Hoffman had to say about free will from paragraph 44 onwards. You are already alive, I know, to the fact that all of that is effectively obiter, given what he said at paragraph 29. No danger due to the state of the premises. But what if there was? And he went on to consider section 13C at length and found that free choice is important. That is a reason for the claim also to have been dismissed under section 13C. I've described in my skeleton argument this choice that the court is being offered by the claimants as a false dichotomy. The claimants say either a claimant freely chose to run a risk or the danger is caused by the state of the premises. I simply say that that is not right. The question that needs to be asked and answered by the court is there a risk of injury due to danger caused by the state of the premises? You don't parse that into separate chunks and say, well, water can be dangerous, therefore there's danger caused by the state of the premises. We are looking to see, is there danger due to the state of the premises? I've offered in my skeleton argument, it's paragraph 27 if you want a reference, as a thought experiment, Lord Hoffman's mountaineer, who runs the risk of falling when he goes mountaineering and can't recover. Forgive me, it's paragraph 27 of Tomlinson rather than paragraph 27 of skeleton. And I've hypothesised, what if our mountaineer, who has freely chosen to go up a mountain, got lost? He's looked up in the guidebook that he wants to go up a relatively easy path, but for one reason or another he has strayed into a dangerous area, whether it's a scree slope or a path that leads to a sheer drop or something like that. He never meant to go there, but he does, and he sustains injury. Can that mountaineer, or that user of a mountain, suddenly say, well, this is now a danger due to the state of the premises because it was accidental of me straying off the path that I intended to take? My submission is that the answer to that is of course not. Where in paragraph 27 Lord Hoffman says, go mountaineering and you run a risk that you might stumble or misjudge, the point he's making is, it's not due to the state of the premises, it's due to what you're doing. That mountaineer has chosen to go up a route that he might fall off. My mountaineer hasn't. He tried to go up an easy route and has accidentally gone astray. Does the fact that my mountaineer has gone astray make the mountain dangerous? No, the mountain was the same mountain all along.
Well, that doesn't sound like the test, does it? I mean, premises are not inherently dangerous in the sense that, unless there's a sort of Rylands and Fletcher type liability for things which come out of the premises, they only become dangerous because somebody goes into them. So, in that sense, somebody is doing something in order for the danger to eventuate in injury. So it can't. You say it was the same mountain before and after, and so it was, but I mean it's the same rotten trapdoor before and after. It's only when somebody steps on it that it becomes a problem.
Yes, it is certainly true that unless an individual interacts with the premises, we are never going to be asking ourselves the question, is there injury caused by danger due to the state of the premises? The rotten trapdoor creates premises that are in a dangerous state. My point is that the mountain that Lord Hoffman addresses in his paragraph 27 is not in a dangerous state. It's just a mountain. Mm. And the fact that you put yourself on a part of it that you didn't mean to, where you might fall off, doesn't change the nature of the mountain, which wasn't in a dangerous state in the first place. Even though now you suffer injury because you've gone somewhere where you didn't intend to and have come a cropper, a hazard. Yep. So to be clear, I'm saying firstly that there is no need for an either-or choice between risk of injury being caused by the choice of an individual or the state of the premises. That is a false choice. It's either caused by the state of the premises or it isn't. If I'm wrong about that, then what I would go on to say is, come at that again. Proposition 1 is that it's a false choice to say it's choice versus state of premises. But I expand on that in this way. The distinction, if a distinction is to be drawn, should not be between choice versus state of the premises, but activity versus state of the premises. That is, if there is an election to be made at all, and I say that there shouldn't be, I say that the simple question is, are the premises in a dangerous state or not? But if I'm wrong and we've got to make a choice, it's either one thing or another. The one thing is the activity of the person, not an activity freely undertaken. That is, there's no reason to distinguish between the deliberate action of Mr. Tomlinson and the accidental action of Mrs. Brown. On this issue, if I may, I'll go to Keogh, which you'll find beginning at page 299 of the bundle, although I'm taking you in at page 307. It's a passage that your lordships have looked at already this morning, paragraphs 28 and 29. The threshold question is not whether there is a risk of suffering injury by reason of the state of the premises, it's whether there's a risk of injury by reason of any danger due to the state of the premises. Thus, in order for the threshold question to be answered in the affirmative, it must be shown that the premises were inherently dangerous. In the present case, there was nothing inherently dangerous about the fire escape, no physical defect to it, no element of disrepair or structural deficiency, nor was there any hidden danger. The only danger arose from the activity of Mr. Keogh. And Mr. Keogh, it was a choice. But the danger arose from his activity, not from the state of the premises. And my submission is that it's the activity that one distinguishes from state of the premises if I'm wrong and there is a choice to be made. But my primary point is there isn't a choice to be made. Either the state of the premises is a danger or it isn't. And in our case, on all fours with Tomlinson, it isn't. I'm just pausing for a moment, my lords, to see if I can skip ahead slightly. I'm mindful of the time.
Yeah.
I move on to deal with the position in relation to Tomlinson. If I'm wrong about everything I've said so far, that is, if there is a dichotomy, and it's not merely activity versus state of the premises, it's choice versus state of the premises. And so the court is concerned with the question of, well, did Mrs Brown choose to undertake a risky activity or not? In my submission, she did choose to engage in a dangerous activity. That's driving. If you drive your car, there is a risk that you will be injured in many ways. The fact that the risk that eventuated is an unusual one does not mean that driving is not a risky activity. If she had left the road and hit a tree, that would be a different set of circumstances, but still arising from driving. But I offer this thought experiment. Supposing she had lost control of her car and was on her way towards the lake when a large vehicle coming the other way caught her car as she passed in front of it, with similar tragic consequences. Does the accident of the fact that there was a vehicle coming the other way mean that it was not what she chose to do, the driving, that resulted in the accident? My submission is no. It makes no sense for the legal test to depend on quite precisely what the outcome is. I think I need to take that point again. Can I just take a moment to sketch it out on my notes in front of me before I do that, just to make sure I catch the point quite precisely. Thank you. Yes, it's simply this. I risk repeating myself. It's simply that there's no distinction to be drawn between the individual who freely chooses to enter the premises and then negligently comes upon the thing that causes them injury, Mr. Tomlinson.
And presumably you would say the same if the motorist who ended up in the water had ended up there because somebody had crashed into the back of his or her car and pushed it through the fence.
Yes. Exactly. Premises are still not in a dangerous state. I can move on to deal briefly with section 1.6a, which is prayed in aid of the claimant's position, but which I contend does not, in fact, assist the claimant at all. The thrust of the claimant's argument, you'll find section 1.6a on page 12. This is the Countryside and Rights of Way Act provision. As I understand it, the thrust of the claimant's argument is, well, look, if you're going to restrict liability in relation to natural features of the landscape for this class of non-visitor, that must mean that a duty is otherwise owed in relation to these natural features of the landscape, because otherwise why would you need to restrict it out? Here we have a similar point to that which I made in interpreting section 1.1a. Not every risk is a danger. And in section 1.6a, we find that we don't even need to get to the question of does the natural feature of the landscape constitute a danger, because any risk arising from those features is excluded. It is illuminating in my submission to look on to section 1.6a B. That is, a cause of action is also excluded for people climbing over a fence. Climb over a fence and sustain injury, tough, no duty is owed under this Act. By parity of reasoning with the claimant's point, that would mean that fences are dangerous, because if you climb over them, you might be injured. That fences are not dangerous because you might climb over them and be injured is shown in the case of Phillips, which you have at page 370 of the authorities bundle. It is a relatively simple point, but page 370. And the relevant, this is a child climbs over an ordinary fence, falls and sustains injury. And the relevant part of the decision is in paragraph 16 on page 375 to 376. And I don't wish to labour the point at all. I simply make the point that here the judge has observed, and it's most quickly seen on page 376, starting about halfway through the section that I sidebarred on 376, where the judge asks, was there something wrong with the state of the premises? And he goes on to say, no. Perfectly ordinary fence, nothing wrong with it. Put another way, no defect, no latent problem. And if the claimant was right in relation to section 1.6a, that there must be a duty owed in relation to water, because otherwise it would have been unnecessary to exclude it, it would follow that there is also invariably a duty owed in relation to a fence, whether it is dangerous or not. Not so in my submission. I add for completeness that the public using land pursuant to a Countryside and Rights of Way Act right are there as of right, and it would be a strange position in my submission if someone who was allowed to be there for a statutory purpose is owed less of a duty than someone in Mrs Brown's position who is a trespasser simpliciter. Before I move on from section 1.1a, I do need to take us on a short tour of the relevant authorities. I will start, if I may, with Donoghue and Folkestone, which you have at page 165. And I'm taking us in at page 176.
You'll bear in mind that we haven't looked at these.
Yes, I will bear that in mind. I'm seeking to make good my proposition that when there is a danger attributable to the state of the premises, the thrust of the authorities is something wrong with it or there's a hidden defect. Donoghue, paragraph 33, is the starting point for that position. And the judge in our case properly worked on the basis that there's no suggestion of a hidden danger in our case. I can see a highlighter, so I'll just pause. Paragraph 33. The obvious situation where a duty under the 84 Act is likely to arise is where the occupier knows the trespasser may come upon a danger that is latent. Our judge paragraph 7D of the decision, if you need the reference, noted that there's no suggestion of hidden danger in our case. I'll take you next to Keown. In fact, I'll just make sure that I need to. I'm conscious that you have been taken to it already. No, I do need to. I need to take you to paragraph 13, even though you have seen it already, simply to underline the point. This is not danger due to the state of the premises. I've already taken you to page 307 and I'm not going to repeat that. Dealing quickly with the cases relied on by Mr. Weir. He says the decision in Ratcliffe, which you have at page 141, suggests danger due to the state of the premises because of the presence of water. Not so in my submission. Rather, in Ratcliffe, the claim was determined on a section 1.13 basis. Risks from the pool were obvious and the claimant accepted that risk. No consideration was given to section 1.1a. And it was unnecessary because the claim failed under 1.3.
Well, say for this, you wouldn't normally get to 1.3 unless you'd gone through 1.1a.
Yes, although my Lord will probably have observed already that that isn't necessarily the route that the judges take in deciding these cases.
I think that's a perfectly fair response.
Thank you. The example that I have cited by way of meeting Ratcliffe is the case of Grimes that you have at page 352, where we have another young claimant, an 18-year-old woman who dives into a shallow swimming pool, head hits the floor, and she's rendered tetraplegic. And again, the question of section 1.1a isn't expressly identified and separated. But on page 366, between paragraphs 84 and 85, it's the last few words of 84 and the first few words of 85, we have the judge's conclusion. The risk here was the risk inherent in diving. The pool was not unsafe for diving. So, insofar as Ratcliffe is said to support the proposition that, someone hit their head in water, therefore water means that the premises are in a dangerous state. Well, in Grimes, someone hit their head in water and the premises were not in a dangerous state. I make the point simply to observe that it's necessary to go to the statutory question and ask, are the premises in a dangerous state or not? White and St Albans, I won't take you to, save to observe that once again, section 1.1 wasn't the matter that was in issue because the claim failed under section 1.3. Likewise in Edwards, and I'll give you a page reference for White if you want it. It's on page 79. The relevant passage is on page 81. Likewise in Edwards and Sutton, page 379 onwards. What we have here on page 392 is a judge who assumes, I take that word from the judgment, I'm prepared to assume that there was objectively a danger arising from the state of the premises. And that assumption merely allows the judge to get on with dismissing the claim under section 1.3c. It's not a finding as such under section 1.1a. It's one of those cases in which it's not necessary to deal with 1.1a, and it's not in fact dealt with. Likewise, Staples, the chap who slips off the cob. Was there a danger due to the state of the premises? The question was neither asked nor answered. The claimant has placed no reliance on Liddell and Bristol Council, so I don't propose to address you on that unless you particularly want me to. Right, thank you.
Yep.
Thank you. So, in conclusion on section 1.1a, I'm inviting you to find that the judge was right to do what he did, and I say he did do it, but either way, I say that the claim should be dismissed under section 1.1a because there is no danger due to the state of the premises. Rather, this accident happened because of an inadvertent driving into the lake, and it is not a choice to drive into the lake or otherwise. That is the vital question on whether or not the premises are in a dangerous state. Unless I can assist further on 1.1a, I propose to move to 1.3c. As in Tomlinson paragraph 38, I remind you that we begin from the assumption that there is no duty, and then we need to look at the facts briefly as they concern the first defendant.
So wait a minute. What are we doing here? We're assuming that there is a danger, are we?
For the purposes of section 1.3c, we must assume that there is a danger due to the state of the premises, because if there isn't,
we must assume that your clients know that Mrs Brown may come into the vicinity of the danger, or somebody like Mrs Brown.
Yes.
And the question we're asking is this a risk which, in all the circumstances of the case, against which, in all the circumstances of the case, your client might reasonably be expected to offer highway users some protection?
Exactly that. You know from the pleaded case that the First Defendant is a relatively new entity, a charity that exists for the purposes of enhancing inland waterways and caring for them for the benefit of the public. And you know that it leases land some distance from the accident site to use as a water sports base, but has a licence to use the whole of the reservoir. So it is accepted on behalf of the First Defendant that there is therefore some degree of occupational control, and I summarise that in paragraph 29 of my skeleton, should you want a reference for it. But in those circumstances, should the First Defendant, with its licence to use the lake for water sports, be expected to offer highway users some protection? I'm deliberately beginning with the First Defendant, and what I say next applies only to the First Defendant. I will then come on to matters that apply equally to the First and Second Defendant together. What protection would it be reasonable for the First Defendant to provide? Two things are suggested by the claimant: signs and barriers. Signs. Where? We've got no authority to put them on the highway. You have to query whether or not there would be any point in putting them off the highway, because by the time the claimant has got round the bend to the location of the reservoir, any loss of control has already happened. But even then, how can the First Defendant erect signage on the Second Defendant's land as part of a reasonable requirement? And a sign saying what? Don't lose control and crash here because there's a reservoir. Drivers don't need to be told, don't lose control and crash your car, whether it's because there's a tree off the highway or a reservoir off the highway or a wall. Drivers know that they need to drive in such a way as to retain control. So a sign would, I submit, serve no purpose. What about barriers? Well, again, no power to put up a barrier on the highway. Should First Defendant, with its licence to use the lake for water sports, be reasonably required to erect a substantial crash barrier on the Second Defendant's land to prevent highway users who lose control from going into the reservoir? In my submission, it is not at all realistic. And since it is a circumstance in which the first defendant must reasonably be expected to offer protection. As far as the first defendant is concerned, the claimant is simply miles off success. I've illustrated, I hope, why I say that the claim against D1 is unsustainable on this basis. But there are factors that apply equally to D1 and D2 that suggest it wouldn't be reasonably required for the occupier of land adjacent to a highway to barrier off its lands to stop road users coming onto it. The first is the observation made by the learned judge below, that if occupiers are held to owe a duty to restrain people within the highway, that has got potentially extremely wide ramifications. And Mr. Weir says, oh, well, that doesn't matter because it's only the circumstances of this case that matter. I say it does matter. It absolutely matters that, as a matter of principle, occupiers of land should not, in my submission, be required to do what the highway authority has power to do, and the occupier does not have power to do, which is to put a barrier on the highway to deal with anybody who loses control. The learned judge, I say, was right to observe that any manner of off-highway obstacles might cause injury. And on the claimant's logic, if you leave the road and hit a tree or a wall, then that is a danger due to the state of the premises, because on the claimant's logic, there's a risk of injury if you drive into a tree or a wall, and therefore there's danger due to the state of the premises. I say all of that is wrong. But if it's right, then any occupier of land that's got a wall or a tree, or I've even suggested a prickly bush that a cyclist might fall into, has got an obligation to fence it off.
I don't think Mr. Weir goes that far. He says they might, depending on the circumstances.
Indeed. And my submission is...
All he says is you can't rule it out.
And there is the difference between us. I say you can rule it out. And one of the reasons for that is that if you don't rule it out, who knows where that line stops. I'm just checking that I've taken into this paragraph in Tomlinson already. I think I have.
So it's a floodgates argument.
Yes. No, I didn't take you to paragraph 59 of Tomlinson, and I need to do that, please. And it's the passage that I've put a sidebar next to at the top of page 255 within the speech of Lord Hutton. Where he says, starting at the end of the first line on the page, namely, it's contrary to common sense and therefore not sound law to expect an occupier to provide protection against an obvious danger on his land arising from a natural feature, such as a lake or cliff, and to impose a duty on him to do so. That is, and I should perhaps have begun at the bottom of page 254, what Lord Hutton is doing here is saying, look, that was always the law and it still is. It's contrary to common sense to expect occupiers to put up protection in relation to obvious dangers on their land. And in that sense, White Lion is a completely different case. What Mr. Weir says about this is correct. It is not the law that if the risk is obvious, then there's never any duty under either Occupiers Liability Act. But when one looks at the facts of White Lion, we have someone who is at home from home in a hotel and therefore expected to be off his guard, who suffers injury on something that is held to be not only a foreseeable risk, but a risk that is reasonably likely to happen. Whereas in our case, we've got someone driving, and drivers are reasonably expected to be aware of obvious risks. I do also seek to support the proposition relied on by the judge that there are no cases of occupiers being held liable to prevent knowing but unintentional trespass. None. My Lord Justice Davis is right in my submission to ask the question that he does. Isn't there a difference between the knowing and the unwitting? And Mrs Brown falls into the category of someone who must have known, subject to the reality of the situation. But there's no question that someone driving through the fence thinks, oh, maybe this is okay. Anybody doing that knows that they are trespassing. And there are no cases of occupiers being held liable to knowing trespassers like that. The closest that the claimant has been able to get is to reach to Canada and the case of Vinot, where, again, what we have got is one of those peculiar categories. That is, there's a hidden trap in Vinot. Would it assist me to take you to that case? I'm conscious that we've not spent any time.
Well, I don't think Mr Weir has relied on it, but if you wanted to rely on it in some way, then do.
I will limit myself to this. You know the facts. It's a chap who's snowmobiling and goes off down somewhere where he doesn't realise he's trespassing and strikes a bar that's been put across. In those circumstances, because a trap is created, liability was found. But that is not our case. There is no trap here. I'll just see if there are any of those other cases. Now, nor does the claimant rely in particular on barns and wards, so I'll simply tell you that in my submission the way to distinguish barns and wards is to observe that in that case, pit dug next to a highway. The rationale behind that liability was that you couldn't use the highway safely because the pit was there. Whereas in our case, there's no question you could use the highway safely. And that even overlooks the fact that that's an 1850 case, and so based on different laws, which is under consideration here. That is all I need to deal with in relation to section 1.3c, unless there is anything that... Thank you. No, section 1.4 I can deal with simply by saying, well, everything that I've just said about 1.3c applies equally to section 1.4.
Yeah.
I'm conscious that I dealt with it section 1.1a at greater length than 1.3c. I don't want that to be taken as suggesting lack of conviction in relation to 1.3c. Quite the opposite. It's just that there's more involved law in 1.3a. Unless I can assist you further, then I can conclude there.
Thank you very much. Yes, Mr Mohn. Is there a repetition of what Mr White's already said?
Well, Lords, no. I accept, for today's purposes, that there is no difference between the position of the First Defendant and the Second Defendant, so I will try not to repeat anything that Mr White has said. There are one or two points of emphasis, but I adopt what the First Defendant says because we are in the same position.
Yep.
Mr White explained in his submissions on 1.3c that the First Defendant might be in an even better position than the Second Defendant in some respects, because he says, fairly enough, the bit we lease is a mile away and all we have is a licence to use the reservoir, whereas my clients own the reservoir. But everything that he says about 1.3c I adopt, and I'm not going to add very much in that respect. There are three things that I would like to deal with, if I may. The first is to look at the question of 11A and the danger due to the state of the premises. I will not repeat what Mr. White has said. What I would invite the court to do is to focus on the inquiry as to a state as being important. And in my submission, this is what particularly the Master of the Rolls in Donahue was attracted by. And it was, in fact, the error that this court had fallen into in Tomlinson, because the decision in Donahue came after this court's decision in Tomlinson and before the House of Lords' decision in Tomlinson. So that when we look at paragraph 26 of Tomlinson in Lord Hoffman's judgment, and so this is page 245, he refers to Lord Phillips's comments about the Court of Appeal decision in Tomlinson, and notes, top of page 246, that the Master of the Rolls had said that he had been unable to identify the state of the premises which carried with it the risk of the injury suffered by Mr. Tomlinson. That was the error that Lord Phillips felt the Court of Appeal had fallen into in assessing Mr. Tomlinson's case. And the comment that Lord Hoffman then reproduces in his speech, it seems to me that Mr. Tomlinson suffered his injury because he chose to indulge in an activity which had inherent dangers, not because the premises were in a dangerous state, is cited with approval. And indeed, he goes on to say that that is, in his opinion, central to the appeal. In a dangerous state, in my submission, is a useful shorthand for the confusion of section 11A, which has led to Mr. Weir's suggestion that there's a tautology involved, and the need referred to by Mr. White to distinguish between risk and danger. I adopt what Mr. White says about that. Not every risk is a danger. What we should be looking for, I would submit, is premises which are in a dangerous state. And state in that is important. And that, in my submission, is clearly demonstrated by paragraphs 26 to 29 in Lord Hoffman's speech, because he repeatedly refers to the fact that the mere where Mr. Tomlinson had his unfortunate accident was not dangerous, not in a dangerous state, didn't pose any dangers that anyone wouldn't have expected. So at paragraph 26, he cites Mr. Justice Jack's finding at first instance there was nothing about the mere at Brereton Heath which made it any more dangerous than any other ordinary stretch of open water in England. That reappears consistently throughout the speeches in Tomlinson. But he goes on, and this is now Lord Hoffman's summary of the findings. There was nothing special about its configuration. There were no hidden dangers. It was shallow in some places and deep in others, but that is the nature of lakes. And he goes on in paragraph 28 to say, at letter F on 246, the water was perfectly safe for all dormant activities. It must therefore follow, in my submission, that his conclusion at paragraph 29 is, I have not found a danger due to the state of the premises. What I have found instead is a danger due to something else. And it happens that the something else was Mr. Tomlinson's dive into a perfectly ordinary lake. But it didn't have to be. The question is, are the premises in a dangerous state? Likewise, and Mr. White took you to paragraph 69 and Lord Hobhouse's judgment, and I won't repeat that, save to say, to page 258, save to observe that he again lists many ordinary, natural and physical features of premises. Those are his words. But it is important in my submission to go on to paragraph 70 and look at what Lord Hobhouse actually felt was the crucial element of the case. He says in the first 4 lines, there was no danger arising to activity on the land. Therefore, 4th line in paragraph 70, the claimant has to found his case upon a danger due to the state of the premises. His difficulty is that the judge has found that there was none, and he has accepted that finding. Therefore, his case fails in limine. And that is the ratio of Lord Hobhouse's judgment. It is not the premises are dangerous, but because Mr. Tomlinson did something, I'm going to ignore that. And Lord Hoffman, the same. He does not find a danger, find a dangerous state, and then step in to say, but because Mr. Tomlinson, you chose to do this, I'll ignore that. And the error that the claimants fall into here is demonstrated in their skeleton argument at page 27 of the appeal bundle. I just invite your lordships to consider it, and the reasoning there. Mr. Weir has developed it today, but essentially they are saying there was a danger due to the state of the premises, and the court, his words, stepped in and found that in fact that wasn't the cause of the accident. But that isn't supported by the reasoning of Lord Hoffman or Lord Hobhouse. And since Lord Scott and Lord Nichols agree with Lord Hoffman, that is the majority ratio. Lords, I don't think I need to add anything else on 118 to what Mr. White has said. Save to endorse, and I run the risk of repeating this, but to endorse that even if Mr. Weir's analysis of this is right, and what the court is looking for is a reason to step in and step away from a danger due to the state of the premises, and say, well, actually, on a causation basis, this is caused by something else, some choice that you've made. I would invite your lordships to look at paragraph 27, 246 in Tomlinson, and the way that Lord Hoffman puts that. 4 lines down. Mr. Tomlinson was a person of full capacity who voluntarily and without any pressure or inducement engaged in an activity which had inherent risk. That is no different from Mrs. Brown. There is inherent risk in driving. She chose to drive. Nobody is suggesting, and the House of Lords was certainly not suggesting, that Mr. Tomlinson appreciated the danger that he was putting himself in with his dive when he failed to execute it properly. As Lord Hoffman goes on, the risk was that he might not execute his dive properly and so sustain injury. The risk to Mrs. Brown was that she might not take a bend properly and sustain injury. It happened to be very serious injury, but that doesn't mean that there is a valid distinction between what Mr. Tomlinson did and what Mrs. Brown did.
Is this a convenient moment, Mr. Moan, or do you have a little more to go?
5 or 10 minutes, my lord.
Oh, well, you can have 5 minutes.
5 minutes. I want to mention briefly section 1, subsection 6A. Mr. White has dealt with that, and I adopt what he says. It is an ingenious argument, but it is, in my submission, a flawed one. And the chronology that I particularly want to draw to your lordship's attention is this. At the time of the accident in Tomlinson, the Act had not been, the Countryside's Right to Wear Act had not been passed. The accident was 1995, the Act was passed in 2000. By the time that the House of Lords gave their judgment in Tomlinson, the Act had been passed, but it wasn't in force. Didn't come into force until 2004. And the House of Lords' decision was in 2003. So, Mr. Weir's argument was available to the claimants in Tomlinson. Because what Mr. Weir says is not that the Act has changed anything, but that the Act implies that those dangers which are listed as not giving rise to a duty to people exercising the access rights do give rise to a duty to ordinary non-visitors, other non-visitors. So the claimant in Tomlinson could have said, look, Parliament has said, in respect of these things, that these people who exercise access rights are not owed a duty. That shows that I was, because Parliament has changed the law. He didn't make that argument. In fact, the Act was mentioned in the submissions in Tomlinson, but by the defendant, which said, and this is the bottom of page 236, defendant's submissions, see the amendments to the 1984 Act by Section 13 of the Transferred Rights of Way Act 2000, not yet in force. And at the top of 237, the 1984 Act does not readily impose a duty to guard against natural features of land. Yeah. That is our position. It was the position that the House of Lords agreed with in Tomlinson. As I say, a genius argument, but it is not right, and it is not consistent with what the Lordship said. My Lords, I would be repeating Mr. White, I think, if I said anything very much about 13C. I do want to make the point, particularly on behalf of the second defendant as the landowner, that there is a valid, very valid objection to the idea that this threshold is not something for the court to be concerned about, that there is not some wider liability here to other occupiers. Because it is significant in my submission that if the claimants are right here, every occupier with land bordering the highway will at the very least have to think about whether they need to put up a barrier. Of course, this decision doesn't determine that one way or the other. But if this is something which doesn't even give rise to a duty, then they don't have to think about it. And that is, I would submit, correct. So the wider context does matter. There are miles and miles of highway, and much of it is adjacent to things which could potentially cause injury. Landowners are assuming that that's not a problem, unless there is a particular hidden danger or a defect or something particular, something unnatural, something unusual, something inherently dangerous about that land. This, what the claimants urge on your lordships, would mean that all of those occupiers have to think about whether or not the mere existence of the features of their land might pose a risk to people who come off the highway. That shouldn't be the law. Right. My Lord, unless there's anything else I can assist with.
No, thank you. All right. 10:30 tomorrow.